If our first panel of the morning, private military contractors, has been a subject much in the news lately, I think all of you know that surveillance and the Foreign Intelligence Surveillance Act and the attempts to revise the Foreign Intelligence Surveillance Act and to cure some of the problems the technology has created with regard to the Protect America Act of 2007, which sunsetted and which was not passed, has raised a whole host of issues, both law and policy, concerning what should be the role of Congress in providing oversight for the President's surveillance programs. And we have our second panel this morning to deal with that issue. And the chair of that panel, who will introduce his panelists, is Professor Bobby Chesney from Wake Forest. Bobby, over to you.
Thanks, Scott. Good morning. So in this session, we turn to a topic of tremendous importance, but also tremendous difficulty: how best to structure the legal rules that govern collection of foreign intelligence, particularly when it takes place with a U.S. connection or domestic aspect. This is an area in which the complexities of technology intersect or commingle with the obscurity of dense statutory text to create really high barriers to entry for those of us who would really drill down and understand the topic at a granular level, which is what you really have to do. Fortunately, we have an outstanding panel of experts to guide us through that task this morning. I'll introduce them in a moment, but first I do want to take this time to give you a sort of bird's eye overview of the topic area, sort of a context setting to spare the panelists the need to do the same. So let's talk about the collection of foreign intelligence where it has a domestic connection. For much of the 20th century, well, let me back up even further than that. This is something we've been doing in this country since its inception, and indeed into the Revolutionary period, and it's something that for most of that period was understood to present policy challenges, practical challenges, technological challenges as well. But for a substantial period of time, the government did not necessarily perceive this as being an area where it presented legal challenges as well. It was an area that did not take place with a mindset that there needed to be warrants, that there needed to be some sort of process ex post or ex ante to vet the legality of foreign intelligence collection with the domestic aspect. That, of course, begins to change as the climate of how we think about intelligence collection in the law began to change in the 60s, and then, of course, especially in the 1970s. One of the real landmarks in this evolution, of course, was the 1972 Supreme Court decision in the so-called Keith case, where the court held that the Fourth Amendment did apply and a warrant of some sort would indeed be required for an intelligence collection, at least with respect to purely domestic rather than foreign security threats, when it involved U.S. persons in the United States. The court did expressly refrain in that case from opining on whether the same constitutional rule would be true if the threat was a foreign intelligence threat, if we were collecting domestically on a foreign intelligence threat. The court reserved that decision, but the question had been put. The question was out there. And there were many who argued that the same result should apply in that circumstance. The fact that that question was out there, combining with other elements of that reform-minded era, especially the elements that followed in the wake of the Church and Pike investigations, created an atmosphere in which a statutory solution emerged. And that, of course, was the 1978 Foreign Intelligence Surveillance Act, or FISA, which is mainly what we're here to talk about. Now, FISA was not primarily concerned, or even perhaps concerned at all, with external overseas intelligence collection. It was primarily about domestic collection when you're collecting on foreign threats. But the real trick is how do you actually operationalize that line? If, to use some language that David Criss, a well-known commentator on this topic, has used, if we want a situation in which NSA can turn on the vacuum cleaners, more or less, without worrying about individualized warrants and judicial proceedings on the front end, if we want them to be able to do that as to the activities of the Red Army in the Soviet Union or in the Eastern Bloc, if we want them to be able to do that, but at the same time we want to have a particularized warrant-oriented proceeding for internal or domestic collection, How exactly do you draw those lines? It sounds easy to describe it in those general terms. Those are easy cases, but how do you operationalize it? And what they came up with in FISA was rather complex. The operationalization of that line takes place in the definition of electronic surveillance. And it's an awfully complex definition. If you've ever spent time with the FISA statute, you know that this is where you first run into the real feel for statutory density when you look at the definition here. It combines multiple elements: citizenship or U.S. personhood, location of the parties to the communication, means or methods of communicating. All of these variables become terribly important. The net result of it was to create a definition where the FISA warrant requirement comes into play when you have activity that meets this definition of this complex definition of electronic surveillance, but otherwise you need not resort to the FISA mechanism. Well, much has occurred since 1978. Among other things, the technology of communications has become much more complex. In some of the innovations of technology, here we can think of the internet, we can think of stored electronic communications, email, cell phone technology, VoIP, Skype, things like this. These things present challenges to some of the presumptions that were implicit in the definition of electronic surveillance, especially in the geographic elements of the definition of electronic surveillance. So technology changes, and the definition doesn't. And arguably, we get a delta there of some significance. Other things change. Foreign intelligence collection has remained significant, of course, throughout this period, even with the demise of the Soviet Union. In fact, as we moved into an area of dealing with non-state actors, clandestine organizations such as Al-Qaeda, if anything, the significance of intelligence to our operations and our international security, the intelligence collection process has, if anything, gotten more important. And then finally, of course, you have specific developments post 9/11 that have brought this issue to the public's attention in a very dramatic way. And of course, here I'm thinking primarily of the, whether you want to call it the terrorist surveillance program or NSA warrantless wiretapping, the post 9/11 use of NSA to, without a warrant, surveil activities that apparently, at least in part, would have come within the scope of the FISA definition of electronic surveillance, and therefore, according to FISA's terms, should have been conducted pursuant to a FISA warrant or not at all. Now, that particular revelation has sparked many lines of controversy. From a legal perspective, there are really two lines of controversy I want to draw your attention to. One is a question of the scope of the president's war powers and whether the president, either by virtue of his Article II authority as commander-in-chief or otherwise, or perhaps by virtue of the September 18th, 2001 authorization for use of military force, whether either of those sources of executive authority suffice to exempt this particular collection operation from the terms of FISA. That, of course, is a tremendous controversy. Secondly, and I think this is a distinct line of argument, it's drawn attention to the practical question that I referenced a moment ago, whether changing technology has moved the nature of communications, electronic communications in particular, so far away from the presumptions built into the 1978 definition of electronic surveillance that the geographic elements of the original definition don't make sense for the current climate. That's a really interesting and complex question, and it's driven a lot of the reform effort, if not most of the reform effort that we've seen in Congress in the past couple of years. At least that's how I perceive it. Of course, that reform effort eventually produced the Protect America Act, which was a ultimately short-lived bit of legislation that, and this is a gross generalization, but had the effect of narrowing the range of circumstances in which a FISA warrant would be required in a way that arguably responded to these technological changes. It's expired now, although it's important to note that, as I understand it, orders that were put in place under its rubric remain in place, at least for the time being. In any event, Congress is now in the midst of the very messy process of figuring out how exactly, if at all, to revive what was done in Protect America Act or do something slightly different, or indeed whether it should reform FISA at all. It seems that there is widespread consensus that some form of reform is required and is going to take place. Exactly what form it will take is as yet unclear. Part of the problem is there are related but somewhat collateral issues such as immunity for the telecommunications industry, retroactive immunity, that have become tremendously hot political footballs, and at least that issue, perhaps others, are helping to create a situation of stalemate for the moment. Hopefully that won't last forever, however the issue breaks. When the issue does heat up again, and it's always going on in the back rooms, I guess, but when the issue does come back to the forefront, some of the most significant players will be the people we have here to help explain this to us today. And so let me do a brief introduction. I could go on for the entire period just trying to detail the accomplishments, achievements, and experiences of our illustrious panelists. I'm simply going to introduce them with very brief introductions. First, we're going to hear, and we'll hear from each of them for about 10 minutes at first. I'll then conduct a moderated dialogue for a little while, very much like our last panel, and then we'll go to the Q&A. First, we're going to hear from Ben Powell. Very grateful that Ben could be here today because he's a rather busy person. He's the General Counsel for the Office of the Director of National Intelligence. Second, we'll hear from Lisa Graves. Lisa is the Deputy Director for the Center for National Security Studies. Third, Jim Baker. From 2001 to 2007, Jim was Counsel for Intelligence Policy within OIPR, the Office of Intelligence Policy Review. That's the DOJ body responsible for interacting with the FISA court, the FISC. And last but not least, Suzanne Spaulding. Suzanne is currently with Bingham Consulting Group. Previously was chair of the ABA Standing Committee on Law and National Security, executive director at the National Commission on Terrorism, and general counsel for FISA. So we couldn't have a better slate of persons to speak to us about this issue. And I will now turn the floor over to Ben, and feel free to speak either from the mics there or come up here if you prefer.
Okay, I'll just speak from the table here. I'm going to repeat everything Bobby said, but I'm going to say it a bit differently, which is often the case in this very complicated debate. First, let's go back to 1978 and the Foreign Intelligence Surveillance Act, responding to the abuses brought to light in the 1970s, the Church and Pike Commission, the way that the intelligence community was used to target political opponents of whatever administration was in power from whatever party. It seemingly didn't have a certain party bent to it. That culminated in the 1978 passage of the Foreign Intelligence Surveillance Act. And back then, in 1978, they were also dealing with technological complexity, and they were dealing with the very difficult problem of how do you bring intelligence operations into some type of court process while preserving the flexibility that's necessary and the inherent uncertainty of much of our global operations, particularly when you're dealing with technology and you may not know what you're going to get or know with any kind of certainty exactly the outcome of your operation. So very different from your police operation where you're targeting a drug dealer in this apartment. You have a fairly good idea of what you are seeking and what you may get. Very different when you're dealing with kind of worldwide operations on a global scale, many of which are highly sensitive and classified. So they came up with FISA. FISA had a critical distinction in it. And what it said was, in the legislative history, it says this act does not deal with the international signals activities currently conducted by the National Security Agency. That's what the legislative history says. Just to give you an idea, and I'll probably end the panel right here by actually reading from the FISA statute to Bobby's horror. But that's what the legislative history says. How did they do it in practice? Let me read it to you. The intentional acquisition by this is what one of the definitions of electronic surveillance is. The intentional acquisition by an electronic, mechanical, or other surveillance device of the contents of any radio communication under circumstances in which a person has a reasonable expectation of privacy and a warrant would be required for law enforcement purposes, and if both the sender and all intended recipients are located within the United States. That's just one of the definitions of electronic surveillance in FISA. There's 3 others I won't impose on you. But that's how they operationalize that statement about exempting a number of the international signals activities done by the National Security Agency. So what does that mean? So in 1978, when we did international interception of international communications targeted at people outside of the United States. There was no FISA court order required. What FISA did set up is a four-factor test that you'd have to look at. Who is the target of what you are doing? Where is the target located? How are you doing the interception, and where is the interception being done? I think we've gotten to a place now over the past 2 years where I think everyone has at least some agreement that the four-factor test, while interesting and makes for a lot of work in where Jim formerly worked, what's really of concern is who is the target? Who are we targeting? What are we trying to do? Is it a U.S. person? What are the constitutional rights that apply? This brings us to 2006 and 2007, and I think a growing recognition of the technological changes that had happened in the world, a large shift from what had formerly been satellite and radio communications to cables, wires, and that FISA had not been updated to reflect that shift. This problem did not spring to life in 2006 or 2007, nor did it spring to life in 2001, nor did it spring to life in 1995. As best I can tell, because I have an interest in history and I'm continually looking into this, I'm certain by at least 1990, and perhaps as early as 1987, people at high levels of the government recognized the problem. I will also say that as best I can tell, people realized at these high levels that if they opened FISA up, they would be dealing with exactly the debate we are dealing with now, that it is a difficult area, it's a complex area, it involves classified operations, it's a horribly dense statute, it's difficult to explain, you will be subject to charges of Big Brother spying on Americans, of rogue agencies out of control. And I'll leave it to others' judgment of the wisdom of the Director of National Intelligence and acting on some recommendations made by me that we wade into this debate. I don't know what he feels given all the charges that have been hurled at us and kind of the road we've gone down here, whether perhaps those people who said, let's just let the problem sit there and kind of try to duct tape things instead of wading into it, because who knows what will happen. Bobby mentioned we had the Protect America Act. I'm not going to spend too much time on that. Happy to answer questions on that. We had the Protect America Act passed in August. Once that was passed, there were a lot of concerns about some of the language of the Protect America Act, but also an interest in putting a more long-term foundation in place. So over the 6 months after the passage of the Protect America Act, we worked with the Senate very closely. That produced their bill that passed the Senate, passed the Senate Intelligence Committee 13-2, and passed the Senate by a vote of 68 to 29. Why were there 68 votes in the Senate for this? Why, in this environment, did we have a strong bipartisan vote for this bill? And the bottom line answer is both sides compromised. Nobody will claim it as perfection, but it gives the intelligence community the tools it needs operationally to do its foreign intelligence targeting work, and at the same time accommodates a lot of concerns that were raised by members about language in the Protect America Act. Let me go over a few of these. First, what's provided for in the Senate bill. The FISA court is going to review our targeting procedures. What does that mean? That means that I'm representing to you that we are targeting foreigners overseas. Well, how do I know that? Well, there has to be a set of procedures that our agencies have to follow to make that conclusion. The FISA court's going to review those targeting procedures to say, yes, you are in fact targeting foreigners. You are not targeting people here in the United States, and we've reviewed your procedures for assuring that is the case, and we are comfortable that as a constitutional matter, as a legal matter, those procedures are adequate to satisfy the legal requirements. That was in the Protect America Act. We submitted those procedures to the FISA court in August, and they approved them in January of this year. The Senate bill goes beyond that. It requires court review of our minimization procedures. And that's a whole separate panel on minimization, but for those who aren't familiar with this particular world, minimization essentially means that it is true that we encounter information about U.S. persons in our global operations. Minimization is the process by which we minimize that U.S. person information. And what I mean by that is if you pick up Ben Powell, in an intelligence report you may read about U.S. person number 1. Or, if it's possible, we would just leave out any reference to this U.S. person number 1 if it's not part of the significant foreign intelligence that we're reporting out. This is not a concept that's limited to the intelligence community. Obviously, law enforcement's dealt with this problem for many years. Mafia cases, hitmen call other hitmen and call their mafia boss. They also do call out for pizza and dry cleaning and other things. So minimization as a concept is not something that's limited to this. So we've added that into the Senate bill. We also have FISA court review of the certification signed by the Attorney General and the Director of National Intelligence, authorizing the acquisition activity. We have an unprecedented provision in the Senate bill for the first time in this country's history. If we are targeting a U.S. person's overseas, we need a court order. So it may come as a surprise to some people, but if we were targeting a person overseas in our intelligence work prior to the passage of the Senate bill, and since the Senate bill is not law today, it's currently the case today, we do not need a court order to target a U.S. person overseas in our work. There's a procedure under Section 2.5 of Executive Order 12333 that was signed in 1981 by which the Attorney General authorizes those activities. So this is unprecedented, that we agreed to go to the FISA court for targeting U.S. persons anywhere on the globe. A major concession, and I'll say not one without considerable controversy inside the intelligence community, but the decision was made by the Director of National Intelligence and the Attorney General to recommend to the President that he agree to endorse a bill with this provision in it. And finally, what Bobby referenced, liability protection for people who assisted us after September 11th. Subject to great misunderstanding and I think some distortion in some of the debates that have happened out there. So let me just talk briefly about it. It does not say anything about the legality of any activities after September 11th. It does not say anything about the legality of the terrorist surveillance program. It makes no finding or protection for any government officials or any Department of Justice opinions. What it says is if the Attorney General makes a certain certification requiring a number of elements, those elements including the activity occurred after September 11th, it was to detect and prevent terrorist attacks, and it was done on the person was told that it was authorized by the President, and its legality was certified by the Attorney General, an intelligence community head, or a deputy thereof, then the person would receive liability protection for that activity. It makes no finding that, or try to wade into the controversy that Bobby referenced. With that, I'll leave it there. I'm sure there'll be many questions. I'll leave as much time as possible for that and turn over to Lisa.
Thanks, Ben, and I'm very happy to be here, and I appreciate the invitation that Bobby extended to the Center for National Security Studies. Ben and I have a slightly different view of the law, it's fair to say. At the Center for National Security Studies, we work to try to ensure that our national security policies are consistent, in our view, with the Constitution and civil liberties and privacy. And we have been extensively involved in this issue of the Foreign Intelligence Surveillance Act, efforts to modify it, as well as the debate that many of you recall in 2005 about the Patriot Act, which involved a lot of conversations about wiretapping and having court orders, and which I was surprised to, I suppose, observe in December of 2005, after spending a year discussing how the Patriot Act modified FISA, that FISA was apparently optional in many respects, or in some significant respect. And so I know we're going to have plenty of time to talk about particular issues, but I wanted to focus on 3 points that were raised by Bobby and by Ben. The first is about the issue of the complexity of FISA and FISA's history from my historical research and our research at the center. The fact is that I suppose it's fair to say that FISA is a complex statute, and I suppose it's fair to say that many statutes are complex statutes. I don't think that it's really more complex than many other statutes, and I think that when it's viewed in light of the problems that it was seeking to address, it's actually very clear and very easy to understand. So, as Bobby mentioned, the Foreign Intelligence Surveillance Act provides, in its terms, the exclusive procedures for wiretapping that occurs on these shores. It does have that geographic element to it. And the essence of that is that it basically says that if something meets this set of definitions, then a warrant is required from the FISA court. The FISA court is a court that sits in Washington, D.C., that is housed in the Justice Department, and whose members are appointed solely at the discretion of the Chief Justice of the United States. The current FISA membership is, I believe, 8 Republican appointees to their original district court position, 3 Democratic appointees, and there's also a court of appellate review that has 3 judges, all of whom right now are Reagan appointees to the bench. But leaving aside the makeup of the FISA court and the FISA court's role over the years, the essence of the law was that the government would need to go to the FISA court in order to conduct wiretapping on these shores. And the way it proceeded was to say that all wiretapping that meets these definitions requires a warrant from the FISA court, with 3 exceptions. The first exception was in time of war. For 15 days following a declaration of war by Congress, the government would not need to go to the FISA court. The second was that there was an exception for emergencies in which there were procedures in place to determine that an emergency had occurred. There's been criticism that those procedures were too elaborate. The time period was extended in 2001 to be 3 days from the time of an emergency to go back to the court and say, here are the reasons why we conducted this emergency surveillance. And the third exception was what's known as the embassy leased line rule, which is to say when you're targeting an embassy in the United States that is conducting communications directly with other foreign countries or its home country, that you wouldn't need to establish probable cause, you wouldn't need to go through the ordinary rules of the Fourth Amendment. Those were the 3 exceptions to the warrant requirement, a requirement that was exclusive under the law. And the way that the definitions worked, and I think was very sound, was to say, for example, in F1 of FISA, I believe that particular provision was directed at primarily a program that was notorious at the time, which was called Operation Minaret, which was an operation by which Americans were watch listed in the NSA's activities in terms of its satellite surveillance. Particular Americans were targeted for surveillance. And in essence, F1 of FISA says you cannot target a particular American who is in the United States without having a warrant. In terms of F2 of FISA was designed, in my view, to prevent Operation Shamrock from being restarted. Operation Shamrock was an extremely controversial program by which the NSA, at the direction of several administrations, had engaged in the wholesale acquisition of virtually every telegram to businesses or residents in the U.S. to or from anyone in the U.S. And so the way that provision is written is to protect Americans from having their communications acquired by the NSA and then sifted through or analyzed later. So it says that the acquisition of communications to or from a U.S. person is not permitted without a warrant. That was the rule. F3, not to go into too much detail, but F3 was about purely domestic to domestic communications. It says it applies to communications between a person in the U.S. to another person in the U.S. And F4, in essence, in my view, was about anything that didn't somehow meet this category, but that affected the privacy expectations of Americans. For example, bugging your home, videotaping within your home. That's my general view of the way the law was written. It was written, as all laws are, to respond to the particular factual record that Congress had before it. The record Congress had before it was one in which there had been tremendous abuses, both in terms of targeting and in terms of the acquisition of countless private communications of Americans and the subsequent analysis and retention of those communications, and then the dissemination of them, the dissemination as a secondary matter. So you have that is the climate. And then historically, there's been a lot said about how we do have a tremendous change in technology over time. The fact is, and I think David Chris, who's an expert in this field, has said quite clearly that over time, both internationally and domestically, both communications traveled by the air and by cable. It's true that there's been a digital revolution in this country. The fact is that the first digital cable was laid 20 years ago. I think has been mentions that perhaps there was an awareness in 87 or 88 that the world was going to become more digital. And I would say to you that this should be of concern to you from a couple of standpoints. The first is that the fact is that more and more American communications do transit outside the U.S. More and more communications, people have more international communications than they ever did. When I was growing up, you could actually hear the signal going through the oceanic cables. You'd have to wait for your uncle, for example, to respond to your call. Now it's instant, basically, around the world. And in essence, you have a situation in which there is more globalization, more Americans, 40 million Americans travel abroad, work abroad every year. More Americans serve abroad in the military, more Americans serve abroad for their country. Students go to school abroad. Businesses operate abroad. U.S. businesses, we're having more communications with our colleagues who work abroad. And more companies, even like Dr. Pepper or JCPenney's, are actually foreign companies. So there's been an enormous globalization, and that has presented, I'm sure, some difficulties for the intelligence community to get a handle on this booming amount of communication that now occurs internationally. But I would say that it's important to think about what FISA was intended to do, and also what the Protect America Act permitted. And if I could, it seems to me that what has been permitted, or what was permitted, was, in essence, access certainly to an enormous number of international communications of Americans, at a time when more and more Americans are communicating internationally, at a time in which more and more of our communications are basically digitized, which means that they're searchable endlessly and savable in smaller and smaller bytes of storage capacity. And I would say that in that circumstance, we have a duty to examine whether we need greater privacy protections for Americans' communications, not fewer, not to reduce the privacy rights of Americans to that of foreign nationals who may be on one end of those calls, but to ensure that the Americans who are involved in international communications have their privacy rights protected. And I would also say that I have deep concerns that the way that the program or that the PAA programs have been articulated would permit, in essence, the acquisition not just of an enormous number of international communications, or whatever the NSA decides to select from that ocean of communication, but also perhaps to gain access to facilities in the United States through the internet service providers and phone companies, and in the process acquire purely domestic communications. And it's certainly been the administration's position, and perhaps a long-standing executive branch position, that anything lawfully acquired can be searched, can be retained. It might not be disseminated, it's been said, with your name if it's not germane, but it can be retained. Your intimate private emails, your intimate telephone calls, and they can be retained and searched. Now let me just conclude my portion of this, which is to say that we believe that it is very important that the NSA have the tools to target terrorists, and Ben spoke about targeting. The problem is that the PAA and its the statute that would follow it in the Senate form defines the realm of activity to be, in essence, any time that you have a reasonable belief that a person is located outside the U.S. and your objective is to gather foreign intelligence. So that's the targeting. That's in essence on the superficial level, perhaps not the below the surface secret level, but that's on the superficial level what the law requires. And it seems to me that that definition, in essence, could meet any number of 5 billion people who are physically located outside the United States, communicating with any number of 300 million people located within the United States. It's a very broad definition. When the administration has come to Congress and said, don't worry, we really are targeting, we don't have the capacity, even with technology, to possibly consume all this information, analyze it, we would be overwhelmed. We really do target. There was an effort in the Senate Judiciary Committee to codify that assurance, which was resisted by the administration. these are very complex issues, but at the heart, they are about the Constitution and about the rights of Americans and about our security and our liberty and securing our liberty. And so I'm happy to answer any questions subsequently.
Thanks, Lisa. Jim, we'll go to you.
Thanks. I've got so many little notes here. I have no way I can possibly get through them in the time allotted, so I'll just do the best I can. Let's see. First of all, just a couple of preliminary points. First of all, thank you to Duke Law School. This is a great event, and to Bobby for putting together this panel. I greatly appreciate it. And it's important that we keep talking about these issues and trying to gain greater understanding about these issues so that the public can make an informed decision and urge our elected representatives to do the same. So I currently work at Verizon Business, but I'm here today in my personal capacity, and anything I say is my view only. It doesn't reflect the views of my current employer or the Department of Justice, my former employer for that matter either. Okay, just to start out, a couple history points then. The general purpose of FISA was, on the one hand, to protect us from our adversaries, hostile foreign intelligence services, terrorist groups, and to make sure that the American people were secure. And it was also intended to make sure that the American people were safe from abuses by our intelligence community, which unfortunately had happened, beginning at least in 1945 with Project Shamrock and continuing through the 50s, 60s, and 70s. To add to Lisa's hit parade, there was another example that folks were concerned about, and it's reflected, I think, in one of the definitions of electronic surveillance having to do with wire communications. And this was a situation where I think it was in the late 60s, early 70s, when the predecessor agency to the DEA was doing a drug investigation in New York City, and the drug organization was using a variety of different payphones to conduct their business. And it was simply too difficult for DEA, the DEA predecessor, to get a Title III, and on Title III is the criminal wiretap statute, to get a criminal wiretap authorization on these various telephones. They didn't think they would be able to establish probable cause, and so they went to NSA and asked NSA to go up on international switches going into New York and collect all the communications, and then sort through them and see which ones had to do with drug organizations and which didn't. And that presented a number of different problems, but the idea there being that you had a concern by Congress Congress wanted to regulate that type of activity, and so it actually did try to regulate the collection of information about people overseas. There were both ends, right? You had people in the United States conducting the drug activities, but you had people abroad as well, and so both of those sets of people were targets. So I think it's more accurate to say that that Congress was concerned at the time about international wire communications, even if the target was overseas, and it did subject that to the statutory regime that Bobby started talking about. As a result, I'll stay with that point for a moment. As a result, if we have there's sort of flip sides to these things. On the one hand, yes, that then throws that kind of collection under FISA, and you can't do it without a warrant. But at the same time, you can do it with a warrant. So it provides a mechanism for obtaining authorization to do that kind of collection in an efficient manner, provided you have probable cause. And so in situations where the intelligence community is worried about or had been worried about particular people overseas, phone numbers, whatever, there was in place and has been in place and could be in place today mechanisms to deal with those kinds of situations. You can go and get a FISA warrant to deal with that. So I just want to make sure that that's clear. All right, let me come back to the points I wanted to try to make today in the few minutes that I have. Three points, and I'll try to elaborate on each one of them. First of all, the statutory regime that we have today regarding the collection of content of communications as well as information about those communications, which some have referred to as metadata, is just way too complex in my view. It will remain so even with the passage of one or another of the various bills that are pending or something else that would come later. And that it seems to me that once Congress finishes its work on these bills, it still has more work to do because the regime is simply too complex. Second, I'm going to urge or suggest a couple of things to think about when people are thinking about what it means to say FISA modernization. And to me, at the end of the day, what you're really talking about is not technology. You're really talking about who should approve surveillances under what circumstances. Should it be the executive branch? Should it be the court? Should it be somebody else? And I'll try to unpack that a little bit. And And if I have time, I'd like to make the point that the new collection authorizations that we're talking about do not necessarily make us safer. It's an important point to remember. We're going to have, at some point in time, because the PAA, Protect America Act authorizations will expire, so Congress needs to do something. But at the end of the day, the mere fact that we have these new authorities, you should not just go to sleep and think everything's hunky-dory. There's still a lot of other issues that we need to address. So let me try to deal with as many of those as I can. Okay. In terms of the complexity, one way to think about this, it seems to me, to understand it or to get a better grasp of the complexity of it, is to think about it from the people who actually have to do these jobs. And so if you take a hypo, I've used this before, but U.S. military in Iraq raids an al-Qaeda safe house and finds in pocket litter, which is like the stuff you have in your pockets when you're apprehended, a piece of paper that has an email address on it. And they pass that to the U.S. intelligence community and say, do something with this, okay? So that works its way through the intelligence community, and then what do? Well, okay, now they've got to think about lots of different types of collection. As I mentioned, you've got content, which is what's actually said in a phone call or what's actually in the substance of an email, and you've got non-content. Okay, so let's think about content for a minute. All right, well, we've got electronic surveillance we want to do, so maybe we'll try to do a traditional FISA, maybe we'll try to do a Protect America Act directive, maybe we'll do a Title III, which is a criminal statute. Is that going to apply? Depends on where people are and what we're thinking about in terms of what our purpose is. And we're also going to do our Executive Order 12333 collection outside the United States, which is what NSA has done for many years. Okay, so that's just electronic surveillance. Now, but since it's an email account, it's going to have something in the account to begin with, so I want to get what's in there. I want to search it. All right, well, I can do a FISA physical search. I can collect it under the Protect America Act as well. I could get a Rule 41, which is the criminal search warrant. I could ask for voluntary disclosure by the provider. There's a provision for that under federal law. I could get a grand jury subpoena, but only if the email is older than 180 days, and then I might have to disclose to the user that it happened, unless I get a court order saying that I don't. And then there's another type of court order that I could go get under something called 2703D. So I could do that too. Again, it only applies for stuff that's older than 180 days. That's all content. But now I'm also interested in just the data about who's this person talking to and where the email's going back and forth from, and what are the date and times of that. That's all very informative stuff. We can talk about that later. Well, let's see. If I don't get that under full content, or maybe I don't have the facts to establish probable cause, I could use a FISA pen register order, and I can explain that later. It's something that records this type of data. I could use a FISA pen trap, or I could use a criminal pen trap, something similar under that. There's a provision called Section 215 of the Patriot Act, which is also under FISA. I could use that to collect historical data. I could get a national security letter. I could get a grand jury subpoena. I could ask for voluntary disclosure. I could get a 2703D order, and I could do 12333 on top of it. This is insane. And the proposals that we have today are going to change things, but they are not going to simplify this structure. And so I think it's especially critical now, and there are people talking about national security letters and reforming those, and I think the complexity issue is very significant there. But in addition, even with big surveillance, the content of communications, it's a very complex regime. In terms of what the FISA statute looked, I figured out what this FISA statute was about, so it can't be that complex. But it is intricate. It is very intricate, and it's very well thought out. And so many times when we were thinking about it, you sort of feel like you're trapped in a china cabinet, because any way you turn, you try to fiddle with the words, you end up knocking something over that's very important, very precious, and very fragile, because things have been built, money's been invested over many years based upon how the statute is written. And so you can mess things up if you're not very careful with it. I think that's the point I want to make about complexity. Too much complexity is dangerous because people, if they don't understand what to do, may hesitate to do things that they lawfully could do, or might get involved in unnecessary legal wrangling. And both of those are dangerous because it will cause people to hesitate to act when they should act, and that will put our security at risk. At the same time, it also puts our civil liberties at risk potentially, because in an area where people have a difficult time understanding what's going on and having to make decisions in real time with a lot of pressure, you're going to sometimes make mistakes. You're going to collect the wrong things, keep too much, and so the privacy of Americans is going to be implicated. So if the complexity. If you're worried about security and you're worried about civil liberties, you need to be worried about complexity. Bobby, how much time do I have left?
Much as you need.
Why don't you go for about?
Yes, my family knows that's very dangerous.
I better step back in then. 3 or 4 minutes. Then.
Okay. All right. So in terms of thinking about FISA modernization, first of all, a couple of major points, I guess. Well, these main points, whether they're major or not, is up to you guys to decide. All right. What's going on again in terms of thinking about FISA modernization? What's going on right now in terms of? I'm sorry. What's going on right now in terms of the various bills, the Senate bill and the House bill, are really, they need to be thought of as efforts to provide a clear statutory basis for the terrorist surveillance program. I mean, that really is what you're talking about here. And so that's why I think Congress has been responding to the pressure to do something about that since August when it passed the Protect America Act, and still throughout the fall and the spring now. That's really what this is all about. And that's why I think we have not yet fully dealt with all these issues of complexity. We haven't really dealt with them. We need another generation of a FISA statute to come after this. And that's why these statutes don't really do this. These statutes are meant for a specific purpose to provide a clear statutory basis for the terrorist surveillance program. I mean, that's what it is. When I talk about modernization also and how you need to think about it, and there's a lot of things we could talk about in terms of technology, as Ben and Lisa alluded to. The key thing is, who do you want to approve these surveillances, and when? Do we want courts to approve them on the basis of establishing probable cause, or do we want the executive branch to approve them? The idea is that technology has changed, and Lisa has touched on that in particular, and so I won't go into that, but technology has changed, and so we're presented with certain problems, and who do we want to approve these surveillances? And the consensus that seems to have emerged is that, well, if we're directing or targeting or focusing on people outside the United States who are not Americans, not U.S. persons, then we're going to say the executive branch can do that under some kind of structure, under some pre-approved basket warrant or concept that's approved by the court, or either before the fact or after the fact. The two different bills differ. But the nitty-gritty of it, the going up on particular phone numbers and so on, that's going to be left to the discretion with procedures of the executive branch. Or do we want some kind of regime where we're going to have individualized probable cause determinations on those facilities? Congress has said no to that so far in both of these bills. A warrant will be required, a full-blown warrant will be required if you're going to target an American person anywhere in the world. A U.S. person, which is a citizen or a permanent resident alien. So if you're going to target a U.S. person anywhere in the world, you're going to need a warrant under these statutes. And if you target any person in the United States, you're going to need a warrant. So it's those non-U.S. persons outside the United States, which can include groups, that are going to be the focus of these surveillances. All right, in about 1 minute, let me just try to touch on this. A lot of these technology issues are focused on the collection of email. And in particular, FISA can be read to require an order, a warrant for email that's email that's collected in the United States because the service provider is inside the United States. Okay. So this is often described as a foreign-to-foreign email problem. And everybody in the room, I think, probably at this point uses email to one degree or another. When you have a web-based email account in particular, the way you really need to think about this is not foreign to foreign, it's foreign to unknown. Because again, when you go back to the perspective of somebody trying to do a surveillance of an email account, this thing on the slip of paper from Iraq, what the intelligence community wants right away and immediately, as fast as possible, is everything in the account that's there already and everything on a going forward basis. You want all that stuff. And you don't really care, you do care obviously, but it doesn't really matter at that point in time. Are they sending it to the U.S.? Is it not to the U.S.? Is it only foreign? Where is it? You just want everything. So that's your sort of mindset as you approach this problem. And then the thing is, once you start your regime of collection and once you grab the stuff that's stored already in the account, you don't know if that's, you want that stuff, and you don't know if it's to or from the U.S. or whatever. You just want an order and you want to get it. And you may or may not be to or from the U.S. When we go up on an email account, the email is going to be transmitted, and we're going to intercept it before the recipient picks it up. Because you send an email, people may or may not read it immediately. It may sit there for a day or two. But we're going to collect it right away. And so we're going to see that it's from X to Y, but we're going to get it before Y reads it. And so Y may be in the United States, Y may be outside the United States. So the problem really is foreign to unknown. So it's the key thing there, and I'll close with this really, the key thing there is when you're thinking about these technology issues, it's nice to say that we're worried about foreign to foreign email, but in reality it's really foreign to unknown email because technology just doesn't allow us to sort out who the identity of these people or their location. So, and I'll try to come back to some of the other points later if I have time, but I'll turn it over to Suzanne about it.
Terrific. Suzanne, it's yours.
Thank you. And let me add my thanks to Scott and the organizers of this conference for a terrific conference and for inviting me to be part of what I think is really, at least so far, been a terrific discussion. I'll try not to lower the bar here too much. And I'm also going to try to keep this relatively brief because I think the discussion is really going to be valuable. And so I will simply say I think it's terrific that we've had this discussion focus almost entirely on what's referred to as Title I of these bills, which is the actual authority and safeguards for the electronic surveillance, because most of the public discussion that has played out in the media on this has focused on what is in Title II of the Senate bill, which is the telecom immunity issue. And it's much easier for the media to understand that issue and for the public to understand that issue, and I think that's the primary reason that it's gotten most of the attention. And these issues have not. So I think it's terrific that the discussion is focused on that. Having said that, I'm going to talk about the telecom immunity issue, only because we haven't yet, and I think it is significant. Before I do, though, I want to also commend Jim for his opening points about complexity in the statute and walking us through all of the things that go through an actual practitioner's mind as they begin a national security investigation, because I think it is also a point that gets lost. And the point I want to draw from that is a reminder that FISA, and electronic surveillance in particular, is not an all or nothing option. This is part of the problem with taking a piecemeal approach, with considering one investigative tool, legal authority at a time. National security letters gets debated one day and then sort of forgotten about while we talk about Section 215 another day, and then a whole other time we talk about electronic surveillance. And in fact, they are all tools available to the government. And as in talking about them in isolation, you get these discussions that imply that if you can't use electronic surveillance, you have no recourse to learn anything more about this target. And that's it, lost, gone, nothing you're going to get to know. And in fact, what FISA says is electronic surveillance, because it is so intrusive, you're now collecting the content of a communication, should be you should start by using the least intrusive means, and you can only get a FISA order if less intrusive means simply are not practical and not workable and can't get you what you need. It is not supposed to be your very first resort to begin to learn about a target. And I think it's really important to keep all of those things in mind. I have been up to testify on the Hill over the last couple of years a number of times, and every time I urge Congress to do a comprehensive review of all of the national security investigative authorities and look at them not in a piecemeal way, but in a comprehensive way, and how they all interact. And look at it in terms of having first analyzed the nature of the threat. Particularly when you're talking domestic intelligence, I think it's critically important. We still don't have a real national assessment of the scope and the nature of the threat inside this country. And we need to do that so that we have a sense of what is the scale of the threat that we're dealing with. And then we need to have a strategy. Given the nature of the threat that we face, both inside and outside the United States, what is our strategy for dealing with it? And then how do these tools fit into that? And we haven't had that kind of an assessment. So on the telecom immunity issue, I think there's a lot of misunderstandings out there. I think it's important to start with understanding that the telecom carriers have, since FISA was enacted in 1978 have always had immunity. I mean, Congress had this in mind. Congress understood that the telecom carriers were under legal obligations to protect the confidentiality of the communications that they carried of their customers. And yet, they wanted to, clearly have them be responsive to lawful government requests to hand that information over. And so what they said in FISA is, you're criminally liable for handing over that information unless, and you get immunity from suit, as long as you are responding to a court order or a certification under this statute. What's the third one? I have the language here.
Well, there's these other provisions that I mentioned as well. You can have disclosures under certain other various provisions of the
Court
federal
order,
law.
statutory authorization, or certification under this chapter. No action can lie in any court against you. So, I mean, it's important to know that that has been on the books, and that was on the books on September 11, 2001, and is still on the books today. So clearly what we're talking about here when we're talking about retroactive immunity for the telecom carriers is a situation in which they did not meet that standard. They did not get a court order, statutory authorization, or a certification under this chapter. The reason that we set up this regime and put criminal liability in here, unless you got this lawful request from the government pursuant to this very clear language, is that the carriers are our last line of defense against abusive government behavior. This stuff is all done in secret. Unlike a Title III criminal wiretap, which you can anticipate you're ultimately going to have to tell the target and justify in court, this is all done in secret and very likely will never see the light of day. So the role of the telecom carriers in this is very important, and we wanted to make sure that they would not hand over this information except pursuant to a lawful request. And the carriers appreciate the clarity that comes with this kind of language. They don't have to second guess. They got a court order, they can hand it over. The problem with the Senate bill, so as we know what happened was then they were apparently approached after 9/11, was a very frightening time in this country with a very real, palpable sense of when the next shoe would drop, a bomb would go off, and very legitimate concerns about nuclear devices, and a time of very high concern, and asked, to cooperate. And apparently cooperated for quite a few years in providing their customers' communications to the government without following the procedures of FISA. So the issue now is, and they've been sued, so the issue now is what to do about this. And my concern with the Senate Intelligence Committee bill and the way that they have addressed this issue is that it basically says, as Ben said, that if the president authorized it, and someone in the executive branch said it was legal, you're off the hook. It's okay. And in fact, as members of Congress have said, you're heroes for responding to your government in a time of need. The reason that I'm so concerned about that is that the administration has argued, as you know, that they did not have to use FISA because of the commander-in-chief authority of the president under Title II. And we have seen in memos related to other activities that they interpret that very, very broadly. For Congress to put into statute that it's okay to violate a statute that Congress has passed and the president has signed so long as the president has authorized it, I think is very troubling. I can't really quite understand why Congress would do that. There are other alternatives. Again, this is an understandable response, perhaps on the part of the telecom carriers. Although I would say that I get the question, what should they have done? What if they'd said no? Well, if they had said no, the administration would have been forced at an earlier stage, as they finally did in January 2005 or later in 2007, after the program had become public and they were under pressure, they finally found a way to take it in front of the FISA court. Well, they would have had to do that sooner, or they would have had to go to Congress and work with Congress to find a way to put this on a more solid legal footing. Had they put it on a more solid legal footing, I think the program would never have been leaked. I think we would not have the questions that are raised today about the legitimacy of any prosecutions that might proceed as a result of this program that was not on a solid legal footing. I think it would have been better for our national security, in short, if this program had been put on a more solid legal footing. But so I think that would have been the right thing to do. That's what the law intended for them to do. That's what Congress intended them to do. They did not do that. But so now here we are in this situation. There have been some alternatives to the Senate language proposed. Senator Feinstein has suggested that rather than just letting the Attorney General certify that this was authorized by the President and somebody said it was legal, and therefore the suits that have been brought by individuals who feel they were wronged by this are all dismissed and thrown out, Feinstein says, well, let's at least have a judge, and a judge of the FISA courts, so that it can be done completely in secret and no leaking, have a judge determine whether there was a good faith reliance. Look at all the circumstances. What was confronting the telecom carriers? What were they told? What legal documents, if any, were they given? And did they have really a good faith basis for concluding that this was a lawful request and that it was lawful for them to comply? And if that's a good faith, if they were acting in good faith, then the lawsuits can be dismissed. That was rejected by the Senate, largely on party lines. There's a related measure that was proposed by Senator Specter and Senator Sheldon Whitehouse that said, okay, let's start with the Feinstein good faith, do a good faith test by the FISA judge. If they find good faith, instead of dismissing these suits brought by these aggrieved individuals, let's substitute the government for the telecom carriers. The government, the telecom carriers relied in good faith. It's not their fault. If there's unlawfulness here, it's on the part of the government. The government should have to defend the legality of this program. So we would substitute the government. That also failed largely on party lines in the Senate. So what the House and the Senate are doing now, in addition to negotiating over the very important issues in Title I, is they are trying to work out a solution to this problem. What the House passed in their most recent bill, they finally stepped up to the bat to address this issue, and they said, how about this? The reason the telecom carriers say they can't go through with these lawsuits, in fact, some of them have been reported to say, we'd really like to be able to get in and defend it because we think we have a good story to tell, but the government tells us it's all classified and we can't talk about it in a court. So the House said, fine. We'll set up a process whereby you can make this case to a judge in camera and ex parte, in secret, in the chambers of the judge, and keep it secret in that way. And state secrets won't apply to this good faith defense lawfulness argument. So that passed in the House. It's on the table. It's part of the discussions going on, and we'll see where all of that ultimately comes out. The final point on that I want to address is this concern that's been expressed that Congress's failure to pass immunity, blanket immunity, retroactive for the telecom carriers is hampering our intelligence efforts because now companies are refusing to cooperate. Not just telecom carriers. The telecom carriers really don't have a choice. I mean, this whole debate is about creating tools to compel the telecom carriers. I mean, that's what FISA is. FISA is, everybody thinks it's an authority for the administration. What it really is it is an ability to compel the communications carriers to cooperate with government requests for surveillance. And that's what it is. It's compulsory. It's not that the telecom carriers can say, no, we don't feel like doing it. Now, the government says, oh, yeah, but okay, we can compel them, but then we have to go into court, and that's going to lose us valuable time, if they are resisting because they're afraid they're going to be sued, and they drag us into court over this. If it is a clear, under the statute, lawful request, I don't think the telecom carriers are going to drag you into court. The government is one of their most important customers and their regulator. And they are not going to just willy-nilly drag them into court for no good reason. I think that's unlikely. On the other hand, what we're hearing is that it's not just telecom carriers who are saying no to the government. There are lots of times when the intelligence community, I was at CIA for 6 years, there are other times when the intelligence community goes to the private sector seeking assistance. And these CEOs are a pretty patriotic bunch. And their inclination is, if there's a lawful way to do this, they're ready to help. They are reportedly showing some more reluctance these days. And we're told that that's because Congress is refusing to grant immunity to the telecom carriers. I have my own theory about why, if in fact they're getting more pushback from CEOs and private sector, why that might be. And I suspect it's because so much of this is played out in the front pages of the newspapers. And because the government they see is pushing the legal envelope. And so where they once would have felt comfortable that if a government lawyer from the CIA comes in and tells me that this is a lawful request and, walks through the argument with me and, I'm fairly comfortable that that's a lawful request. I can certainly see general counsels in corporations today being very skeptical about requests from the government, whether they are really, truly going to be lawful, and then that their cooperation is going to be on the front page of the newspaper. So I don't think it's a question of immunity for the telecom carriers, and I think we need to be very careful as we go down that road that we are sensitive to the message we send to businesses in the future about whether we want them to make sure that they have a lawful request from the government before handing over sensitive customer information. I think that's really critical.
Terrific. Well, I was originally planning to pose all these questions in hopes of spurring some dialogue, but I sense that this dialogue will take off without the need for my questions. Ben, do you have anything you want to say in response to some of the points that have been made?
Yeah, a couple, especially as I see some members of the press out there. I guess I asked Jim for one comment. Jim said that this is about creating a clear statutory basis for the terrorist surveillance program. And the reason I bring that up is I have briefed the press and testified any number of times that what we were talking about here is something that is different than the terrorist surveillance program. Under the president's terrorist surveillance program, what he authorized and talked about in his, and I should pause to say that this phrase terrorist surveillance program is something that became associated with what the president discussed in December of 2005, and is in fact not something, if you read his radio address of December 17th, is actually in the speech that he gave. But the activity he described there that he had authorized was the targeting of communications, one end of which was outside the United States, of Al-Qaeda or associated members or affiliates of Al-Qaeda. So under what he described there, you were talking about potentially the targeting domestically without a court order of U.S. persons. And I want to make it entirely clear that that is not in the Protect America Act, it is not in the Senate bill, it is not in the House bill, and there's been no attempt by the intelligence community to suggest that we could target U.S. persons in the United States, even if they're a charter member of Al-Qaeda, without a court order or create a statutory basis for that to happen. So there was a domestic aspect to the activities described by the president under which we are not trying to create a statutory basis. So I just wanted to comment on that for 1 minute. A couple of other pieces, any one of us could go on for 20 minutes responding to each other. So I will just run over real quick and mention it real quick. Suzanne has made excellent points about all the different tools and how do we synchronize them and what is our homeland threat and looking at all of those issues. I would say, of course, we did do a national intelligence estimate on the homeland threat last summer of 2007. And what we have said in terms of Al-Qaeda is They've got 3 of the 4 things that they would need. 1, safe haven. They have that in the Fatah area. 2, reconstitution of leadership, space to train, and kind of that psychic space to regroup. Trainees have that. What's the piece that they are looking for? And General Hayden's talked about this recently, which is, and we don't believe that there's in any significant way that they have the Western operatives to infiltrate and have infiltrated the United States. That's the piece that we've talked about publicly in terms of them not having, in terms of assessing the homeland threat. And of course, that's our great fear, and that's what we spend so much of our time on, is trying to prevent those operatives, whether it is going through visa waiver countries in Western Europe, and then obviously bringing it into the United States, or the current trial that's going on in Britain in terms of those who want to take down the 10 transatlantic airliners headed for the United States. As far as the Suzanne talking about they were asked to cooperate and somebody told them it was legal, I do want to make sure that what the statute says, it has to be that the Attorney General or the head of an intelligence community element or the deputy thereof was the one who provided a written assurance of the legality. So this was not a low-level person at an agency calling somebody up and saying, hey, why don't you send this on over? We think it's legal. Why don't you just send it over? And then people just blindly send it over. So there are some fairly high-level requirements in the statute. Finally, I'll say in terms of the hampering of the operations, and in terms of whether or not people will just drag us into court one way or the other, I will say 2 things. First, I testified before the Senate a week before the Protect America Act expired. I was brought up to the table and asked to assure the committee that isn't it true, Mr. Powell, that your acquisition authorities will continue after the Protect America Act expires? And I said, yes. And isn't it true that if you have coverage, hypothetically, of Al-Qaeda under those acquisition authorities, you could initiate new coverage under those authorities? I answered under oath, yes, I do believe we can do that. I believe the statute is very clear on that point, and I think we can. And part of the purpose of that testimony was to then use my statements out of context and say, see, there'll be no problem. Sure enough, a leader of the House went on McNeil-Lehrer and read my quote directly in part of a debate on McNeil-Lehrer. I was proven a liar 7 days later when the Protect America Act expired, and some of our cooperating partners said, thank you for the new targets that you would like to cover. We are not adding them. And we said, well, it's clear. How could you not? The statute's clear. The authorities continue. Think you have liability protection? I've told America it was clear. The whole Congress says it's clear, and are all out there calling us liars for even raising the issue. And they said, we appreciate the argument. Thank you very much. It's not your company at risk. You don't have to deal with Sarbanes-Oxley. You don't have to deal with the board of directors. Thank you very much for the new targets. Good luck with that. We'll see you in court. Maybe if you want to go to court, we'll see you 5-6 months later. Then ensued a week-long issue. At the end of that week, I finally had to go to them and say, we have to tell the Congress this is a significant intelligence activity. I want to let you know that that we are telling informing the intelligence committees of this issue of lost coverage. That led to some additional difficult discussions, and finally we got everyone cooperating again. But while it is easy to say, oh, nobody's going to do anything willy-nilly, drag you into court, and statutes are clear and they will do it, unfortunately, that's not the clear world that I operate in, and that was a major learning experience for me, where we had a week of essentially, we were not able to initiate new surveillances on targets that everyone just a week before had agreed were clear under the statute. And all the argument of the world from the Attorney General and everyone in the world was not going to change that fact. And it took us a long time. It took us a week to work through that. So that is an issue we have. It is an issue that we continue to have. I think it points out something we probably all agree on, which is the need for clarity and clear rules in this area.
Any of the rest of you like to respond? Just move down the line, Lisa.
It seems to me that there are a number of factors at work, and given Ben's comments, but also Suzanne's, I think that it's hard to estimate the impact of the loss of credibility of the Justice Department's Office of Legal Counsel on this issue and so many other issues. And certainly from the public comments of someone like Jim Comey, a former federal prosecutor, about the disagreement, and Mr. Goldsmith's comments, the former head of the OLC, about the shaky legal foundation of some of these opinions. In essence, you have a circumstance in which, as Ben said, on the one hand, the Senate bill is written to say if you had the president's command, in essence, and ratification by the Attorney General or the Justice Department that something was okay, then it would be presumed to be legal. And I think that a lot of people might have had a different view of that in 2001 or 2002, but once it became clear that in fact the administration had taken a very strong view, to be, I suppose, understated about the notion of plenary power of the president, of inherent power of the president to act at his discretion, and in essence, in my view, the Justice Department that I used to work at, subservient to the president in assessing the law or willing to do the bidding of the White House and leadership on what the law ought to be. You have a circumstance in which I think there's a great deal of mistrust about not Ben's assurances, but the underlying assurances that kind of got us to this point about what's lawful and what's not. And in essence, it seems to me that from some of the arguments that have been made by some of the administration, and not Ben, but by others in the administration, about the notion of whether the Fourth Amendment even applies. There's an implication in the memo that was released and unclassified last week that the Fourth Amendment actually doesn't apply to domestic military operations, and in essence, the NSA's operations in that respect would seem to be implicated by such a memo that has not been disclosed. And there have been statements made by allies of the administration about whether the Fourth Amendment requires a warrant at all, whether it's just a reasonableness test and what reasonableness means and who is the judge of what's reasonable. And so you have all these little pieces, I think, in a way maybe broader than what Jim mentioned, is that every single link in this chain, there's been loosening, might be one way to describe it, at every single correction or checkpoint. Does it require a warrant? Do we have to have probable cause? Is there any particularity? What does reasonableness mean? Who decides what reasonableness is? Does the Justice Department have a meaningful role? Is it the White House calling the shots? How is the DNI and the NSA responding? Are they responding as the producers of requirements of things that are satisfy the requirements of the command structure within the administration? All these different checks have been dismantled either intentionally or unintentionally in the process of modifying the entire system from within without really, in my view, adequate debate within the branches, and certainly not adequate debate, I think, in the public in terms of what the real effect of these powers is in terms of the number of American communications that will be acquired, the number that will be or have been analyzed, and the number that will be retained for any number of years. So I think that the notion of caution is not due to Ben himself, but is a legacy, an unfortunate legacy of the, in my view, paucity of authority on the part of many legal opinions that were issued by the Justice Department that I have so loved over the years.
Let's get very, very brief responses from Jim and Suzanne if you have further things to add in response to this, and then we'll get the mic circulating so we can hear from the audience.
Sure, Bobby. Just real quick, I'll time myself here. With respect to Ben's point about the statutes providing a clear statutory basis for the terrorist surveillance program. So my point, maybe I didn't make it clear or I tried to cram it together too much with other thoughts, but the basic idea was from late 01 till January of 07, you had a bunch of different things out there authorizing surveillance, including the terrorist surveillance program. In January of 07, I'm saying 01 to 07. In January of 07, the Attorney General sent a letter, I can't remember who it was, to the Hill, I think, saying that, well, we've now got some orders from the FISA court, and so we don't need the terrorist surveillance program anymore, and so we're not going to reauthorize it. That went on for a period of time from January to August. During that period of time, in the late spring and summer, there became a crisis because of a ruling by a FISA court judge, apparently, that resulted in, according, I think, to the DNI, a significant drop-off in collection. And so it produced a crisis that the administration wanted Congress to deal with before going out for the August recess. And so it was the crisis that resulted in the Protect America Act. When people came back from the recess, Congress was not happy with some of the provisions of the Protect America Act, and so then that started this debate. It's still going on today, and we have the House and the Senate bill. So I think what I was trying to focus on was the motivation and some of the history in terms of what has happened. Just a quick point on the PAA. The administration has said that it will not use the PAA to collect domestic communications. Notwithstanding that, the statute, in my view, in the plain meaning of the words, you can read the statute to allow the collection of domestic communications. It's a separate debate we can have. The administration has been quite clear, as a policy matter, it won't do that. But as a legal matter, reading the words, again, plain meaning, I think you can read it that way. Bobby, that's it.
Terrific. Suzanne?
Nope, go for it.
Okay, great. Let's hear from the audience. Sir. This gentleman over here in the aisle.
Thank you. My name is Richard Gerding. I'm from the Embassy of the Netherlands. And I have a question concerning the relationship with the allies of the U.S. and how it works out, the Protect America Act or the FISA works out in this field. Suppose that, say, the German parliament would pass a bill allowing the Bundesnachrichtendienst to listen in on citizens in the US. How would it work out? And what would be the reaction of the American public?
I had this as one of my points I always mean to bring up when I speak, especially to legal audiences, because I think there is probably far too little work, and it would be a very interesting project to do some very good international comparative law articles on exactly the point you raised, which is how is electronic surveillance done in other countries versus the United States. I think you will find, with perhaps the exception of Canada, and I just returned from a conference overseas discussing with people who work in this area, and they are always uniformly shocked by the U.S. system, except with the exception of Canada, of the idea of having a court involved in this at all. In most foreign countries, this is all done, if at all, with oversight by ministerial approval. I'll call them ministerial warrants, but warrants in our system suggest some type of court involvement. It's very much a ministerial system. Not an expert on the German system, so I better not speculate. But if I were to speculate, last time I looked at most countries in Europe, this is all done on a ministerial basis and very little protection. And in many countries, for foreign intelligence purposes, they are frankly where we used to be in terms of an executive, what I'll call an executive branch process for authorizing domestic targeting even for foreign intelligence purposes. So I don't know about Germany in particular. I suspect, though, that you don't even have to pass that bill, that in fact may be the state of law in Germany today. I don't know what the state of the law is for domestic targeting in Germany. Now, that has a lot of different effects when you look at each country. Now, some say you can target all you want, both domestically and internationally, but you can't use it in a criminal prosecution. So they deal with it on a use basis, not on a actual collection basis. So if you make the decision to go this way, you can use it for tip-offs and those types of things, but don't bring those tapes into my court and try to play them in a criminal trial. You can just use it for leads. Jim may be know more about the international system than I do. Jim, do you have any?
Well, you're right. I think what you're saying strikes me as generally correct, Ben. I mean, in terms of how they operate overseas. I mean, I think your point may be, I mean, Americans aren't going to be too happy if anybody's spying on us from overseas. I mean, I think that's the general point. Secondly, but you know, we assume they're probably doing it. Secondly, I think Ben's exactly right, though. The trick about FISA, and the reason, you know, it is in part the way it is that we want to have our cake and eat it too. We want to be able to do very robust and aggressive foreign intelligence collection, and if we find something good, we want to use it in court against somebody to put somebody in jail for life or including the death penalty. So we want to use this stuff that we're collecting for foreign intelligence purposes, and I think you're right. In other countries, I think the UK, and I'll defer to our expert who will come up on one of the other panels, the UK, they've had a very robust debate about what to do, because traditionally, I think, you cannot use the fruits of electronic eavesdropping wiretaps in a criminal court in the UK, and they've made that choice. But it's been a difficult one in light of all the things that have happened in the UK post 9/11.
There's one of the interesting issues that lurks behind this particular topic is what then prevents a casual request to an ally to acquire something about a U.S. target. And I believe there are limitations there, but can you articulate what some of those are?
Well, I mean, one of the first principles you learn, and Suzanne, I'm sure, can attest to this, as can Jim, but one of the first things she probably learned as a lawyer at the CIA is you can't ask somebody to do something that we would not be permitted to do if we did it ourselves, and that's kind of a fundamental principle that runs throughout it. I'm not an expert on the classification level of various signals intelligence arrangements, but we have even stricter signals intelligence types of agreements and arrangements around the world that go well beyond that in preventing it for other citizens of our allies. But that's kind of a fundamental principle that is one of the first things you learn in the intelligence community. It's embodied in the National Security Act. It's embodied in any number of executive orders.
Yeah, it's good to make that clear, because I think a lot of people just assume that, with a wink and a nod, that will go on. In fact, that's part of the culture. Additional questions? Yes, sir. Here's a mic coming down the aisle for you.
Thank you. Tom Houck is my name. I just have a basic question that I've never been able to find the answer to. For one FISA warrant, what is involved? I've heard it's 40 to 60 pages. I've heard it's up to 40 man-hours, that it has to be signed by the Attorney General, just for one warrant. Could somebody tell us?
Everybody's looking at me. All right. It's a hard question. It's an easy question to ask. It's a hard question to answer, and it sort of depends what you're counting. So we have tried. We tried when I was there, and I believe they've continued to try to make this thing as quick as possible. So, for example, one thing we did, we came up with an innovation called Turbo FISA, right? Like TurboTax, you got Turbo FISA, to try to generate these applications as quickly as possible. So you move through a series of fields, you put in information, you put a phone number in one time, you don't have to retype it all the different times, because the statute is what the statute is, and it has certain requirements, and you have to fulfill them. So the paper that gets generated, whether it's this big or that big, doesn't really reflect the amount of work that goes into it. What it reflects is what the system we've built to be able to generate the paper that is legally required. Having said that, again, it depends what you're counting. If you're counting lawyer time at the Justice Department from the time that the request comes in, I don't know how many hours it takes, to be quite frank. But you can also count, you go back from again with my Iraq example, are you going to count the very first time, are you going to count the planning for the mission that went into the determination to raid a particular safe house, that generated the email address, that was passed to the intelligence community where they did their own evaluation, they passed it, let's say, to the FBI did its own evaluation, passed it to DOJ, and then we had some back and forth. That's all involved in the surveillance effort. All of that is part and parcel of the surveillance effort. So in terms of how much do you count, I don't know. If they did their work and everybody did good analysis all the way through, and you come to the Justice Department with a well-done product, then the amount of time from that point to getting your authorization is going to be short. If they didn't get all their ducks in a row, if they left legal questions unanswered, or they didn't think of them, then it's going to take longer.
I would say, as Jim says, it's highly variable. But to give you an idea, though, that these are all approved at very high levels, that is just a basic requirement of the statute. this week, every day this week, I have one of my lawyers is sitting with the Director of National Intelligence. He is personally doing FISA signings this week as the national security signing official because there's only a few national security officials under the statute. We're hopefully going to get a bill that expands that a little bit, but the statute requires essentially a high-level national security official, the director of the FBI, the director of national intelligence, and a few other officials. So every day this week, I've got the DNI, when he comes back from briefing the president, he's sitting with my lawyer going through a stack of FISAs about this high that will go to court, hopefully, sometime this week, and he's going through each one of these. So these are very serious products, and the judgment of our system is it should be for domestic targeting, and I agree with that. Our problem is should we be doing this for the targeting, the foreign targeting procedures of terrorists and others overseas? Should we be getting them caught up in this FISA process? That's our fundamental point here, is we don't think it should be requiring that expenditure of time and making a probable cause showing that is applied domestically in that foreign context. So the answer from my perspective is it is a very significant time investment to make the probable cause showing required by FISA. Sure. Is there a case that I'm in touch with bin Laden and here's my picture with bin Laden and we can do the probable cause showing and very quickly? Yes. Are a lot of cases more nuanced? Is it perhaps even more difficult to put all this together when it's somebody overseas to make a probable cause showing? The answer is yes. These are extensive packages, and it requires a lot of development. I think you'd say the same thing about criminal warrants, that in some cases perhaps you go to the magistrate and the wiretap application and the facts underlying it are easier to show. In other cases, you have to do a lot of maybe more development to make that probable cause showing. It's a very factual-based showing.
Do we have
So
enough? I'm sorry, go ahead, Suzanne.
I just want to make clear that Congress is not talking about requiring that you go through the FISA process and make the probable cause showing on an individualized basis for foreign targets. That's not being debated. Everyone agrees that should not be the case. What's under debate and what Congress is wrestling with and working hard to resolve is what sorts of safeguards do you want to have in place, knowing that a lot of those foreign targets are going to be communicating with people inside the United States, where Fourth Amendment protections do apply. So that's the debate. The debate is not that we would require a probable cause showing, but what are the appropriate safeguards and who should make those decisions and under what circumstances.
Judge, there's a microphone coming down behind you.
You may have just answered the question I had, but I want to make sure I understood it correctly. Is probable cause the statutory standard for the FISA warrant?
It is. It's not identical to the criminal probable cause. Probable cause in a criminal Title III wiretap is probable cause to believe that a crime is or may be committed. And this is probable cause to believe that the target is a foreign power or an agent of a foreign power.
Given that the Henry Seal case held that was sufficient for constitutional purposes, is there really any problem with a constitutional viewpoint with what's being sought with reference to foreign communications? I mean, granted, you may have an American on the other end of it, but didn't the Henry Seal case do a pretty good comparison between Title III and FISA for constitutional standard purposes and say it's okay?
They did. They concluded that that it was an interesting analysis. I think sort of fudged a little bit about the application of the Fourth Amendment and the need for a warrant requirement, but ultimately concluded that it was close enough to pass constitutional muster. And I think that's a fair way to put it.
That's exactly right. They concluded that it's constitutional because the searches that it authorizes are reasonable under the Fourth Amendment. That's exactly right.
As Lisa pointed out, the appointees to the review panel are all Reagan appointees, I guess, but I'm not sure they were at the time of Henry Seal case, and that's the only case they ever had.
That's correct, Judge, and you would know that well.
Thank you.
Yes, sir. In the middle. If you come down this aisle with the microphone, there's a man right in that second row.
Let me ask a slightly more complex question, and I do so as a Canadian working in and before our equivalent FISA court in the Canadian context. What if you have an American who's targeted, American resident outside the United States, communicating with another alleged terrorist in another country outside the United States? Does FISA or anybody in the Department of Justice worry about the fact that FISA is asking to approve a warrant, is being asked to approve a warrant against an American, and that warrant will operate outside the United States and perhaps authorize an interception that may be in violation of the local law where that person is resident? That is a specific case that our FISA court has just addressed and published its decision on, and they did not allow the warrant to be issued because it was outside the jurisdiction, the territorial jurisdiction of Canada. And this is an issue that came before our federal court in an open judgment. And the question was asked, if you know or the court is aware or suspects that the matter may be in violation of the local law where the interception is to be put in place, can that proceed?
Historically, I mean, Congress has looked at and thought about this problem for many years. It hasn't done so in a while, but in the past, around the time the FISA was enacted, it thought about this problem. It didn't try to address it in the original FISA, but it considered it, and there's some legislative history on that. And one of the things they kept coming back to was, we don't really want our domestic courts authorizing what would be illegal in a foreign country. And so they hesitated up until now, and it's only in the Senate bill, if I'm not mistaken, that has the provision that would authorize. It's in both now? Okay. So if some version of that gets passed, then you're going to have that situation. So I think it is. I mean, it's a difficult and tricky situation. The operating, for Canada's one thing, but other countries are another. I mean, in these environments where U.S. intelligence folks have to operate, it's very different from the United States, where the FBI, it's the FBI's home field, right? You have the home field advantage. It's very different here. That's just as a practical matter. And so I guess I am one who is concerned about extending this requirement to the targeting of Americans overseas. I'm not fully persuaded that it's the right thing to do from a legal perspective or from a practical perspective.
The answer is we were very concerned about it. If you read the Senate bill, and I think most of it's incorporated into the House bill, certainly, though I think there's strong support in the House for extending some type of requirement for targeting Americans overseas. I don't think the House differs from the Senate in terms of the House says, yeah, we don't want that. The Senate bill has two different procedures and two different findings, and it's finely detailed. It talks about acquisitions conducted inside the United States targeting United States persons overseas, and then it talks about acquisitions conducted outside the United States targeting United States persons abroad. It is an issue we worry about, and we tried to put a lot of thought into it and work very closely with the members of Congress. But I mean, I will say we acknowledged as part of the discussions with the Senate that there was strong, very strong member interest led by some of the senators to extend this requirement to us. We tried to accommodate that as best we could, but we share the concerns.
It is interesting. It's particularly troubling, as Jim said, if you think of it in terms of U.S., Canada. But you do need to bear in mind that intelligence activities overseas almost always violate the laws of the countries in which they're operating. And that is the nature of espionage. What is troubling here is that you've got a court authorizing it, whereas previously it was the executive branch that would authorize it pursuant to executive order.
Yeah, I would encourage you to look at exactly the details of those provisions.
If I could just add, this strikes me as a question that has come up, as Ben said, in the debate on the floor of Congress, in part because it appears from the public record. This was an issue that was not part of the debate in 2006, and for the early part of 2007 in the U.S. in terms of what the rules were. The rules had been, in essence, settled under the executive order 12333 that President Reagan signed, which required an individualized determination before you could target a particular American abroad. It didn't require a court order to search their luggage, search their home abroad, search their, seize their conversations. Although there was a district court decision in the Bin Laden case that applied to a particular U.S. person who was living in Africa and acquiring their phone communications. And it, again, reinforced the notion that you would have to have an individualized determination at the highest levels before you could target. But in essence, what happened is that it appears that in the review of the program, and some of the legal authorities claimed, Senator Whitehouse in particular was quite alarmed, it seems, that there was an implication in one of the legal opinions that he got sufficiently declassified in a particular way to make part of the public record, to say that the administration had at some point issued an opinion, in essence, saying that the Fourth Amendment, or that they were not bound by Executive Order 12333 in a specific sort of way, and that they were not, and in essence, subsequently, we heard that the president himself, or there was a view that the president himself was not bound by Executive Order 12333, and so this issue emerged of, this problem that we had not, I guess, perceived as a problem when we were focusing on TSP. With all that said, it seems to me that there's an additional issue, which is that some of this activity, particularly since the focus is electronic surveillance and not so much on the physical searches, although there are physical search aspects to searching stored records, stored communication records, the focus primarily seems to be on acquiring electronic communications, digital communications. And what's happened is that the government can, in essence, gather a lot more information domestically than they say that they can acquire outside the U.S. through their traditional means. And what that means to me as a layperson is, a lot of the internet service providers are here in the U.S. Yahoo's here, Gmail's here, Hotmail's here, and not to single them out for a cooperation or non-cooperation, but in essence, as a practical matter, the ISPs many of the ISPs are here. And so what's happened is that I think that there's been tremendous movement on the notion of the facility. What is a facility that a terrorist might be using? It used to be a phone call, a phone, as Jim said, in the DEA cases. It used to be a particular phone number. It might have been a particular email address. And instead what's happened is that it's become that a facility is being used. And in essence, I think one argument is that, and Bobby alluded to that to us privately, not that he knows that per se, but as a question. And so in essence, the question is, what is the facility, this ISP in the U.S.? And so they're not really violating the law in the country, where the res is. They're not in that country when they're doing it. They're doing it here. They'd be acquiring the communications here. But what I would say is that I find the notion that a facility can just be a switch to be extraordinarily troubling from a civil rights standpoint, and extraordinarily troubling just from a mathematical standpoint. If a facility is, that a terrorist might use a facility as a switch, it's like saying, the rule used to be, it's like saying that just because you use electricity, that you can basically go to the electrical hub and gather any information on electricity, because saying that the facility is a switch is basically saying everything's a switch, or the highway that you drive on, that's the method. It's an extremely broad conception. It makes Ron Susskind's statement about Dick Cheney saying that we've got a 1% doctrine into a seemingly reasonable doctrine, because under that conception of what a facility is, you literally have 99.9999999, 7 nines, I did the math, percent likelihood that the rest of the communications are innocent, and 0.0000001, those communications traveling on the switch are not innocent. So I would say that that's not a reasonable interpretation of facility. But the question of where the searches will take place, I think technologically is more likely to take place here, not abroad.
I wish we had time to continue pressing on this, especially now that we've introduced one of my favorite topics, which is the switch as facility and post-hoc audits and all these sorts of issues. Alas, we have to stop because lunch awaits. I'd like to thank our incredibly learned panel. That was a wonderful discussion. Thank you very much.
And thanks to you, Bobby, for putting it together. For those of you who have signed up for the lunch, you should have received a little coupon from Balfour Smith, and that will get you some of the finest food in the Triangle over at the Thomas Center. The Thomas Center, for those of you joining us, you'll go outside and take a right on the main corridor as far as you can go, then take another right, and you'll go outside this building through a little covered walkway, and that goes directly into the dining room, where the Thomas Center dining room, where our luncheon will be held. We will start that luncheon line at 12:45, and then we'll be having our luncheon debate between Professor Peter Fever and Professor Bruce Jellinson about 1:15. The introductions will take place. And then back here this afternoon, at 2:15, we'll be having our third panel, which will take a more international look at efforts to combat terrorism. So for those of you joining us at lunch, we look forward to seeing you in a few moments. For the rest of you, we look forward to seeing you back here at 2:15.